Imagine cops are sitting outside of your house. They're not walking up the lawn, they're not knocking on your door, they're not looking through the window. They're still in their vehicle pointing a thermal device at your house. What are they trying to do? They're trying to see if there's any extra heat coming off the walls. And why are they doing it? Well, in this particular scenario, they're trying to figure out if there's a marijuana grow inside the house. And because of the lamps, it would produce more heat than any other house on the block. If you're familiar with the Fourth Amendment, and maybe you've read other cases, you should recognize this fact pattern. This, of course, is Kyllo versus United States, a Supreme Court case from 2001. Of course, the case dealt with marijuana. And in the decades since, many states have legalized possession, distribution of marijuana. Of course, there's licensing involved and so on, but for the most part, many states now have legal ways for you to possess marijuana. So if you're thinking that police officers no longer use thermal devices, they do. In fact, I have a current case where the officers flew a helicopter over somebody's property to see whether the house and the vehicles that were parked on the property produced any extra heat. They were trying to figure out whether somebody recently used the vehicle and parked it next to the house. Of course, if the vehicle was recently used, it would produce extra heat from the engine compartment, something that the officers would not be able to see with their naked eye. Only with a thermal device would they be able to see that the engine is hotter than the rest of the vehicle. So Kyllo versus United States is still a very important case, and it's one we're going to discuss today. Before we go on, I want to thank you for watching me here on YouTube. If you're new, hit the Lawstache subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch. So let's go on and talk about Kyllo.
Quick message from Lawstache. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lawstache YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lawstache YouTube page. That's Lawstache.
Today we're discussing a Supreme Court decision, Kyllo versus United States, decided in 2001, and much of the facts come from the 90s. Remember, this is the time when we had flip phones, we were barely using internet, yet this is one of the most quoted decisions in the past 2+ decades when it comes to any Fourth Amendment decision with technology. So first, let's discuss the facts here. Federal agents are suspecting Danny Kyllo in growing marijuana at his property. Now, again, because of the 90s, early 2000s, growing marijuana was illegal in that particular state. And here we're talking about Oregon. So officers have an informant, and they also looked into utility bills and saw that Mr. Kyllo has higher usage of electricity based on his utility bills. So the officers drive to Kyllo's property, they park on public street outside of the house and point a thermal device at the triplex. They notice that one of the walls and the garage is much hotter than the rest of the property and the other two properties that are attached in the triplex. With that, they're thinking that Mr. Kyllo is in fact growing marijuana, because most of the time the individuals would use high voltage lamps that produce extra heat, and so the thermal device is registering that heat. Now, knowing that there's information from a thermal device, plus the utilities, plus the informant, they have enough probable cause, they go to the magistrate to get a warrant to search the property. Inside, they actually find a few hundred plants of marijuana. Mr. Kyllo is indicted in federal court on drug charges, and his lawyers make an argument. They say that this search was in violation of the Fourth Amendment. The Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Kylo's officers, or Kylo's attorneys, are saying that this was a search when the cops pointed a thermal device at the property. And this search was conducted without a warrant. And then everything that followed, the subsequent warrant and the search, must also be illegal because there is what's called fruits of the poisonous tree doctrine. Anything that follows after the illegal search must be suppressed. Now, the government makes a different argument. They say there's no physical intrusion, and in fact, the officers always remained on the public street. Without a physical intrusion, the federal government says there is no search. Because there's no search, there's no need for a warrant. So the case goes all the way up to the Supreme Court. And in a 5-4 decision, Justice Scalia says the officers did in fact need to have a warrant. He says that we're no longer in the 18th century. We have to read the Constitution acknowledging that technology has changed. And we know that individuals have heightened or perhaps the highest expectation of privacy in their home. After all, your home is explicitly listed in the Fourth Amendment. It is the first item in the Fourth Amendment. So Justice Scalia says here the officers went into the home using the technology. They never set the foot inside the house, but they used thermal device, which allowed them to see something inside the house that they wouldn't otherwise. And it doesn't matter the fact that this information they obtained while still staying on the public street, and the fact that the information, meaning the heat source, was coming off the walls on the outside of the house. Justice Scalia said that Mr. Kylo still had a reasonable expectation of privacy inside of his home, including the heat source. At the end, here's the rule. Justice Scalia said that if the technology is not readily available to the public, officers do in fact need to have a search warrant if they're using this technology on gathering information from individuals' home. Now, that means that any technology, and since then we have 2.5 decades of more decisions. And of course, we have talked about night vision goggles, we have talked about binoculars. Those things are now readily available to general public, so officers can use them as well without a warrant. But a thermal device, they cannot without a warrant. And if you think they're not doing it still, well, they are. Just like I described in the beginning of this video, I have a current case where the officers used a helicopter to fly over the property and point a thermal device without a warrant. And you have to remember that curtilage, which is the area that intimately surrounds your home, gets the same protection as the home itself under the Fourth Amendment. So let's finish with this. There are 3 major reasons why this case remains one of the most important Fourth Amendment decisions from the Supreme Court. Number 1, this case teaches us that the Fourth Amendment is not frozen in the 18th century. As the technology evolves, so should our reading of the Constitution. So going from binoculars to night vision goggles to thermal devices to drones, as that technology gets better and better, we don't necessarily only need to have a physical trespass to call something a search under the Fourth Amendment. Number 2, this case established general public use doctrine. The question becomes whether the technology is readily available to the general public. And if the general public is using that technology, so can the officers without a warrant. And finally, the third reason is that Kylo reminds us that your home gets the highest protection under the Fourth Amendment. So whether the officers are using thermal or acoustic or any other device that enhances their abilities and they can see literally through the walls, even without the trespass, officers will need to have a warrant because it will be deemed a search under the Fourth Amendment. I hope you enjoyed this video, and if you did, give it a thumbs up. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to shop.lawstache.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I will see you next Wednesday for another deep dive on another criminal case. Thanks for watching.